SJC-13134, Commonwealth versus Glenn Armstrong.
Attorney Smith, whenever you're ready.
Good morning.
Morning.
May it please the court, my name is Sean Smith, and I represent Mr. Glenn Armstrong. For this murder appeal, I have 3 issues I'd like to discuss. Each issue, I believe, is important in itself, but I think given the unique nature of this case, I think greater importance for each issue is earned. In particular, this is an alleged murder of a father by his son, where there is no precipient witness, no credible motive, and far from overwhelming evidence. The first issue I'd like to discuss is the impairment issue, the issue of jury instruction on mental impairment. This, at the end of the evidence, the defense moved for an instruction on mental impairment. The judge denied it.
But there's absolutely no expert evidence submitted. And also, there's a motion in limine by defense counsel to preclude mental health evidence, right, at the beginning of the trial. And we've got no ineffective assistance claim here. I'm confused of what you're doing.
Well, let me address all of that. I agree with you wholeheartedly. This issue is it's in a unique posture, for sure. And this is a situation where a strategic decision was made by defense counsel not to go forward with a mental health claim.
Can I ask it on that? Because the record is slim here. I only have the motion in limine, which doesn't explain the basis for it. Can we discern from this record whether the defendant himself decided not to introduce his mental health into the case?
Well, I can tell you I'm
interested in what the record shows.
The record that was provided, if you look to the motion to suppress, there is some discussion prior to the actual hearing itself where a defense counsel suggests he has 2 possible theories that he may be advancing for trial, one of which is the criminal responsibility issue. He says, however, in that statement, or in his discussion with the court, his client, he believes, the defendant, he believes, does not wish him to do so. There's not much beyond that. I can tell you, and I've investigated this issue in part of my preparation for this case, but I believe it was a strategic decision based on the situation given to trial counsel that he needed to go forward. He could not go forward with that type of case.
Which is the defendant's option. It's the defendant's option.
I believe that is true.
Our case law says that.
Exactly.
On mental health, right.
So the trial counsel's hindered by that. Trial counsel clearly came into an agreement.
And that's what you investigated and came up short on.
Exactly.
Right.
Trial counsel made an effort to exclude mental health issues, as you rightly note, with Commonwealth. And Commonwealth was rightly surprised by the end of the evidence. We had an agreement. We didn't put forward any evidence of mental health crisis or anything that could be used in that case. That was brought to the judge's attention and I think influenced the trial judge's decision. However, I can tell you that I do believe there was substantial evidence, significant evidence of mental health crisis, in large part beyond the photographs, video, but the testimony of the New Jersey officers.
I mean, we have the New Jersey's officers, you know, one, the motion to suppress is based on the caretaking, right? And, you know, he's acting quite strangely. But at the same time, I just don't know if you can have it both ways here, right? Because the officers get to testify of what he was doing and why they, you know, came there and at the request of the hotel manager and what he's up to. But if defense counsel has moved to exclude, you know, any evidence on mental health, I just don't know how it can possibly be an error not to give it based on that limited amount of testimony from the police officers.
Well, just to be clear from my perspective, the error is in the trial judge's decision based on that the issue was not a live issue and that there was no expert opinion. The case law, I believe, is not that. The case law says that the evidence must be significant and it must be critical to the defense.
Was it a misstatement of law when the judge said there's no expert testimony?
Exactly.
So, because lay testimony can't support the instruction.
Right.
Just as it would NGI, right?
Exactly. I mean, that's my position why there is an error.
So when the trial judge said, I'm not giving it because of the lack of expert testimony, that was an error.
Exactly. That the issue was not a live issue and there was no
That's a
expert
different
testimony.
issue with this a live issue, but saying it's preclusive because of the lack of expert, it was an error.
Exactly.
Does he go that far? Does he express, does the trial judge say that exactly?
He says exactly that. That he says exactly that. There's no expert opinion. He also says about the live issue. It's not clear what live issue means.
But we could look at it and see whether or not there was whether the evidence was substantial enough to raise an issue of mitigation.
Right. Because this is a prejudicial error standard, because there was an objection, I would say there is clear error in the judge's decision at that point using that as the rule. The question then becomes one of
But that,
prejudice.
whether or not it was a live issue or whether or not you need expert testimony, which,
I would say both.
well, the expert testimony, I think the case law will show, is clearly erroneous. It was an improper basis for which not to allow the instruction. But if it's not really a live issue, and in fact there was a motion in limine to exclude such evidence, why would that be prejudicial to the defendant?
Part of it is my confusion over the understanding of what it means to be a live issue. It's where, if my take on what a live issue would be is whether or not it's in debate, whether both sides are fighting about whether there is evidence of mental impairment. In this case, I don't believe that's the standard. I think the standard is whether there's evidence significant of it. I think both parties, both the Commonwealth and the defense
All
counsel.
right, so really it's to Justice Gaziano's point with whether or not these officers from New Jersey?
Yes.
Gave sufficient to raise an issue, I won't say live issue, an issue as to whether the defendant was mentally impaired at the time of the murder.
I think that's right. I think that's the issue, and whether or not it's crucial to the defense. As rightly noted, this is an issue that had been worked out beforehand to perhaps exclude this type of evidence.
Yeah, I mean, you can see what the judge is doing because the Commonwealth, had they known, would have hired their own expert, right? So he's basically saying, you set the parameters here. Now you're basically asking for an instruction, and you hamstrung the Commonwealth because you didn't raise it in this fashion. But be that as it may, is it basically a situation where the Commonwealth can't have its cake and eat it? So they can't say that the New Jersey evidence was so bizarre to invoke the caretaker function, and then say that same evidence wasn't evidence of behavior suggesting mental illness.
I mean, there's a justice issue for both sides, both in terms of the defense counsel saying, I'd like to have this restricted, and then the Commonwealth having its cake and eating it too. I
mean, we have to look at the entirety of the record, no matter what side deals are made, essentially.
But, in a case where there's no credible motive, where there isn't overwhelming evidence against an individual.
There's a lot of evidence here.
But not as to the murder itself. The fingerprint, which I'm happy to get to, is by far the most compelling. Oh.
He's in the house. He's in the house. He's run off with his dad's truck, and his dad doesn't let him drive the truck, doesn't let anybody drive the truck in the family. They have a history of strained relationships. He's run away to Virginia right after the murder. It's a lot here. I mean, sufficiency, I'm not sure is going to be your best bet here.
I understand that point. I do think, and I believe.
Before you leave mental health, though, can I go back? Because what I worry about, based on what you submitted in the motion for new trial, or whoever did the motion for new trial, we've got all this evidence that he's schizophrenic, he's been hospitalized 5 times. Can we, and you've also got a 33E issue here, can we decide whether he was competent enough to make the choice not to introduce his mental health, or do we have to send that back?
I think that is a very challenging question, and in investigating the question of ineffective assistance of counsel,
Well, you don't raise ineffective assistance, right, here.
that's right, I don't. And in large part it's the culmination of my own investigation into this case. I believe what had been mentioned earlier with Justice Gaziano's point, that the case law has it where the defendant ultimately has to make some type of determination, and I agree with you, competency.
If he can make the determination.
If he can. I agree with you. This is a sticky situation for me. I am not sure the answer to that. I mean, ultimately, competency is such a fluid situation. It can appear and disappear.
But you're
Well,
asking
but
us,
were you talking about competency or mental impairment for the homicide?
Well, separately, I think just in terms of the competency, whether or not he could make a decision, an informed and knowledgeable decision, whether or not to go forward on a mental and a criminal responsibility defense, I think that's a very challenging situation. But in terms of the mental impairment, I believe the fluid nature of that, I mean, maybe I misunderstand the question. Are you?
Well, you were answering,
Apologize.
I think you were answering Justice Kafka, and I just was wondering what specifically you were focused on, whether you were focused on competency to go to trial, or whether you were, but you're saying it's competency to make that determination, that single determination. Is that a standard that we use, competency to make one determination?
It's not before us though, right?
It's not before you.
Okay.
It is the competency issue in investigating whether or not he was in a position to make that determination. I believe that trial counsel acted correctly in making the determination. So trial counsel, I think, is ultimately in the best position to be able to make the determination whether or not defendant's able to act in a competent manner. I believe that trial counsel determined, based on that a decision had been made and they moved forward with it in the way they did.
Okay.
But we still have this on a 33E basis as far
Yes.
as your argument about his mental health history, which is open to us on 33E.
Yes. And I think if I get to that, I mean, this is a person with an extremely long history. Clearly, this had been the preference of trial counsel to move forward with it on this case because of his prior history. He is an individual who has, and this floods the entire case in terms of the atmosphere of the case, the nature of the crime, the 20 years lost where the father and son had not seen each other, the recent comeback, the death of the mother. All of this comes into play with his own mental illness, and clearly this is somebody who's troubled.
Can I ask you about the fingerprint issue
Yes,
before
please.
you have to depart? We recently, in Commonwealth versus Ronke, talked about this level of certainty and what magic words are required and in Ronke not required. How does that play into your objection to the scientific certainty in this case?
I don't think it's a question of magic words. In fact, you'll see in the transcript, he uses the word opinion. And I think that's what we want the fingerprint expert to do, is talk about it in terms of a fingerprint. Robertson, there's the standard with the fingerprint science.
Because the only case we've ever mandated language is the firearm case. And we did that because it was very controversial.
Right.
It was kind of a middle ground that we took. But we've never said, when an expert proffers an opinion, what the words the expert has to say. And we held that in Ronke.
No, and I agree with that. The Robertson case, in terms of not being retroactive, I fully accept all of that. The issue, though, is it's not the magic words, it's the nature in which he described his science. And I put this in a couple different places, but most importantly on, and if I could, volume 3 of page 127, where he talks about the ACEV leads to an objective conclusion based on 120 years worth of fingerprint science.
Isn't that a matter of cross-examination at that point, though?
This is part of the cross-examination, so this is elicited during the
Right,
cross-examination.
but I mean, teasing this out about whether or not it's a science or more subjective than
Right.
we would like.
No, I agree, but I think because of the nature of science, fingerprint science, and the extreme prejudice that these two fingerprints on the bag, on the head, have for this case, the fact that it was able to come in as this very solid, beyond solid, this is a very 120 years worth of scientific experience, individualized. There's such a debate between both the defense counsel's expert and his expert about whether you can even get to the level of comparison. There's no question that the National Academy of Science, the Gambora case, they talk about, it's at A, C, E, and V, all levels of the analysis of fingerprint science. They're all positions of infallibility. But the way the evidence comes in and is allowed to come in at this case is that once you're able to get to the level of comparison, you have enough information to make comparison. At that point, it's an objective conclusion. At that point, it's 120 years worth of science coming at it. And at that point, it's basically infallible.
And there was no objection here.
There's no objection. So the standard is more difficult for defense. If there's no further questions on fingerprint, I'll just quickly jump to the caretaker function. This was I'm sorry.
Do that. So the 33E review you're asking us to do, okay, it's a case, so we've got the mental health evidence in through the motion for a new trial, and there's a lot of it. Other than that, what else do we have to drop this? Or is that, we would be doing a 33E reduction here based on, really exclusively on the mental health evidence that your client didn't want included in the trial, right?
It's 100% correct.
Yeah, okay. I'm just trying to get a sense, because that's going to be interesting.
I understand the challenge of that. I would also point, Your Honor, to the evidence that came in at trial about the relationships, the 20 years separation, the mother's passing, a seeming reconnection. And I understand that the motive is he wanted to take the truck, but the level of violence and the nature of the crime itself, it just makes that motive, something else is going on. And I would put to Your Honors that's where I'm trying to address that issue beyond, is in the 33. I'll just quickly jump to the caretaker function. This is a matter where it's a motion to suppress, denied by the motion judge, and the motion judge wrote a well-reasoned decision, and clearly substantial deference to the motion judge. And she's correct in the sense that we want our law enforcement officers to be able to render assistance. We want our law officers to be able to, if they see something that may be of concern to the individual for their health benefit or the community at large, we want them to be able to intervene. However, at this point, in this situation, at the moment where they told Mr. Armstrong to take a seat, when they gave him that order, that strongly persuasive suggestion, he was seized, and their intent, despite saying that they wanted to perhaps render some assistance, the actions they took speak more loudly than words. There was no call out for crisis center, there was no call out for EMTs, there was no call out for a shelter or any other social service assistance. This was something where they continued to investigate him, and given what Officer Levy describes as the reason for why they came there, they have a suspicious person.
They're close in time. They tell him to sit down because he's acting peculiarly. He's told them he's working for the Department of Interior for free and a lot of other stuff raising, mental health concerns. Then they immediately hear that he's a suspect in the murder, right? There's like
My understanding of the way the chain, it's a little hard from the motion hearing, is that they go to the bathroom, they knock on the door, he comes out after a minute. He walks himself out to the parking lot, so they're following him. He's objecting himself from the premises. They're out there, he gets aggressive when they're pressing him for ID. They tell him to sit down. At that point, Officer Levy, who's arrived just at that moment, starts asking him questions. At that point, they develop I work for the Department of Interior, I can't tell you my name, I get
Don't
paid.
they run his plate? When do they run his plate?
So Officer Risigliano, when Officer Levy comes there, Officer Risigliano then leaves at some point to go to the vehicle. It's probably like 10, 15 minutes, and he's there for about 15 to 20 minutes. It's when he's gone to the cruiser to get that information, he runs the plates and finds out that there's a warrant.
What's the entire time span are we talking about?
So
How'd you put it?
against a little challenging, but I believe it's about somewhere between 15 to 20 minutes.
Between the time they
He's
arrive and the time they run the plate?
By the time Officer Levy arrives and he's sitting on the ground to the time where Risigliano gets the plate information comes back.
But you were complaining a minute ago that they weren't calling EMT, they weren't looking for, don't they have to establish who he is and make sure he's relatively able to manage himself and obey certain kinds of requests before they start any of that?
I think they could.
They have to assess what they're dealing with.
Well, they had an initial, I think they quickly assessed, both from the information provided to them by the Super 8 hotel and their initial conversation with him as they're walking out from the bathroom to the scene, that he was somebody suffering for some type of mental crisis.
So
At
you're
no
saying
point-
that at that moment, they just should have called for the EMTs to place him in a medical facility without doing anything further?
Oh, I wouldn't have him placed in a medical facility. I think having somebody able to a medical professional, social worker, to be able to address whether or not that he has capacity, whether he's understanding.
Even
whether,
before they've identified him and
Yes.
run that plate?
Just if
to know
you're
what they're
suffering from
dealing
a
with.
medical emergency, I don't think you need to get the identity before you're able to get medical assistance. This person is clearly not well based on his appearance, his behavior, and the statements. I'm not saying at the
I guess
critical
what I'm
moment.
confused about is I don't understand what was unreasonable about what they did.
It's not unreasonable to make an initial inquiry. It's not unreasonable to walk out with him. What's unreasonable is to have him sit down and then don't do anything to assess to assist. At that point, they're not trying to assist him or to aid him.
You want more, you want more caretaking in the
I'd like some more caretaking,
Right, that's right.
some type of indicia that they're there to caretake.
Okay.
If there are no further questions,
Thank
thank you.
Okay, Attorney Borges.
Good morning. May it please the court. Danielle Borges on behalf of the Commonwealth. The Commonwealth respectfully requests this court to affirm the defendant's conviction. In this case, the trial judge properly declined to instruct the jury on mental impairment, where there was no notice given to the Commonwealth of the defendant's intention to raise a mental health issue.
Was there legal error here?
Excuse me?
Was there legal error here?
In what?
In the judge saying, you don't have an expert, so I'm not going to give you the instruction?
So technically, yes, it's not just required for the expert evidence. But in this case, I don't think it was legal error where there was no evidence whatsoever. That could have been a misstatement of the standard used when providing the mental health instruction. But in this case, the judge was correct to deny it, where there was no notice given. There was no evidence, lay person testimony, simply none evidence admitted. And in fact, the motion in limine to exclude any sort of reference or evidence warranted the judge's decision.
But there is evidence from the New Jersey officers that the defendant presumably immediately after the murder, was acting suspiciously. Why is that not enough to give the instruction?
So in that case, the Commonwealth would argue that that interaction with the Mount Laurel police the day after the victim's body was found, even that interaction alone can't speak to the defendant's mental health and potential impairment at the time of the crime. So,
2 days later?
excuse me?
Even though it's 2 days later?
I think it might have been a day after the body was found.
So if he's acting really peculiarly the day after, that you can't sort of think back that that's carried over?
The Commonwealth would argue it wouldn't be in this case because for a whole slew of reasons, the defendant could have been in that moment reacting to what had happened previously, but his actions that moment, so removed from when the victim was murdered, can't speak to his mental
But isn't
health.
that just an argument you get to make in terms of saying there was no mental impairment to the jury? But here, there was no instruction given. What's the standard for giving the instruction? Is it that the Commonwealth doesn't have arguments against it, or what is the standard?
In order to give the instruction, The Commonwealth would argue that there has to be some sort of evidence admitted, and it would be the Commonwealth's position that that interaction with the Mount Laurel Police Department, even if that would be considered, it wouldn't be enough to warrant that mental health instruction where
And what's your best case on that point?
I would believe it's, one second. I would look to the Commonwealth v. Santiago case, that's 485 Mass 416, where this court speaks to be entitled to that instruction on mental impairment, the defendant must, at a minimum, introduce evidence that such an impairment existed at the time of the conduct in question.
And you think a day later is too far removed?
The Commonwealth would argue that where there could, as previously stated, there could be other reasons why the defendant was acting that way following what had potentially happened previously.
When you first gave your answer, you said one of the reasons the instruction was not warranted was because there was no notice given. What do you mean by that?
So under Rule 14B2A, the Commonwealth has to receive notice of the defendant's intention to raise the mental health impairment, and there was no notice given here where that wasn't the theory that trial counsel proceeded on.
Was that to get an examination, the notice, and to start that process?
I believe the notice is given just to put the Commonwealth on.
Right, it's Blaisdell. It's to get the
Exactly.
But when the defendant doesn't use an expert, the Blaisdell procedure is not implicated, correct?
Correct, but it's the Commonwealth's understanding that they need to be on notice prior to trial that the defendant intends to raise some sort of mental health defense. And in this case where there was no notice and where the defense...
Did the judge rely on the lack of notice to deny the instruction?
It's not clear on the record that the judge relied on that, but it is just an additional claim the Commonwealth had made that on top of the lack of evidence presented at trial, there was also additionally no notice, so that didn't comply with the rules.
Yeah, I'm not so sure the rules need to be followed when there's not an expert examination, but we'll look at that.
Okay.
The testimony from the officers, I mean, your best case is that he's weird in this interaction, because we've had this weird doesn't get you the mental impairment line in our case law, but what is he, besides this Department of Interior thing, which seems very odd, is there anything else out about his behavior that's sort of out of bounds, indicating a mental health issue?
The Commonwealth would argue there was not much else besides, I mean, the defendant seemed to be a little aggressive at times. He didn't want to initially give his identity to the officers. I think additionally there was just the fact that his clothes were a little disheveled. He was wearing shorts in January, but I don't think the Commonwealth would argue that that's not overwhelming evidence of any sort of...
Got to be, we're sort of walking a fine line, right? They need the caretaker, otherwise they're intervening for caretaker purposes, so something's heightened. Is it just the fact that he's wearing shorts in the winter and that he says he works for the Interior for free?
So
anything else that, and his hair standing up?
So I believe when the employee from the motel called the officers, they explained that the defendant had kind of been roaming around the property overnight. He'd been coming in and out of the lobby, making inappropriate comments. So when the police responded, they were executing that community caretaking function. And as discussed previously, the entire interaction, it wasn't very long. They were inside, they were outside. When the defendant started acting a little bit aggressive, that's when he was asked to sit down. But then the officers were still executing that community caretaking function. They didn't know who he was.
But is that necessary for the caretaking function to identify who he is?
I would say if he was acting more erratically, like if he was very seriously acting out, potentially being violent, if it was something where they needed to get him assistance immediately, then no, I would say they don't need to go through the process of figuring out who he is. But in this case where he was just acting a little bit out of the ordinary and they felt that they had the time to go figure out who he was, and again, this was only 15 to 20 minutes.
We have zero case law that talks about this, right? We have either you get a community caretaker function because someone's passed out in their vehicle, or there's a well-being check, or you don't.
And I would argue that they were still executing that community caretaking function when they were still trying to figure out who the defendant was. He was just sitting there, again, the weird statements, acting a little bit out of the ordinary. their main goal in talking to the defendant was just to attempt to ascertain whether he needed their assistance.
I mean, it's a weird position that you're in that you have to argue there was enough there of mental disturbance to warrant community caretaking, but not enough to warrant an instruction
And I do
on
think
mental impairment.
there is a spectrum, I think. I think that what entitles a community caretaking function might not be the same as what would entitle the mental health instruction at trial. And I think the officers were properly executing that community caretaking function, as Judge Friezone found in her decision.
We're kind of, now we're in the box, right? We know he's been institutionalized 5 times.
Correct.
We know he's got schizophrenia and he thinks he's acting for God, and he's got all kinds of things and now what do we do? I mean, is this really, and he's killed his father over driving his truck. Is this a 33E lowering the verdict case where we know he's got all kinds of mental health issues, and it's really hard for us to separate out the time frame the way you're talking about?
Mm-hmm.
I mean, are we gonna, is this really a first-degree murder case at this point, given this mess?
Sure. So the Commonwealth would argue that initially the defendant was found to be competent for trial. I believe that was in the end of his 2017 report that was attached in the appendix, the
That's
second
2
one.
years before trial, right?
Yes, trial was in 2019.
Is he reevaluated because he's in 2017, June 2017, we got this very damning portrait of his mental health, right?
Mm-hmm.
Does anybody do anything 2 years later? Or is that the last time his mental health is evaluated?
It's my understanding that it was. I could definitely go check and then provide the court with an update, but my understanding is that that was the evaluation pre-trial.
So he's
Does his counsel make any motion for a subsequent evaluation?
Not to my knowledge, he does not. And they proceed on the theory, which at trial was that, the Commonwealth could not prove identity. So in response to your question regarding the 33E power, the Commonwealth would suggest that the defendant is able at any time to file a motion for new trial. Right now, we don't have an affidavit from trial counsel as to why they proceeded on that theory, whether it was the defendant's request that the mental health route not be taken.
But we have this information in front of us, and you have to satisfy a gatekeeper at this point. So we have this information in front of us, and we are allowed under Dowds and some other cases to look beyond the trial record and look, as we did in Dowds, at mental health history to see if the defendant was fairly convicted of first-degree murder. So given his mental health history, can you tell us why he was fairly convicted of first-degree murder?
Sure. The Commonwealth would argue that that mental health history doesn't overcome the evidence at trial that the defendant killed his father with deliberate premeditation and extreme atrocity or cruelty. The jury heard that the defendant brutally beat his 83-year-old father. The medical examiner testified that while the victim was still alive, the defendant put a trash bag over his head, tied a belt around his neck, strangling him. The victim was found dead inside a room behind a closed door in a locked house that showed no evidence of any forced entrance or exit. The severity of the beating inflicted upon the victim, there were multiple bruises to his torso, his face, lacerations on his face and eyes, and he suffered from 11 blunt force injuries on his head and torso and 6 fractured ribs.
Remind me with the mental health, he's got his mental health is connected to acting violently, right?
I do believe in his mental health history eval there were comments that occasionally, depending on if he was provoked in certain ways, he would react aggressively.
Yeah, and does that suggest, sort of following up on Justice Casiano's question, I mean, counsel's walking a fine line, but do we know whether, unless we satisfy ourselves that one, this was considered, don't we have to send this back to evaluate whether his mental health was evaluated during those 2 periods, or if it wasn't, why it wasn't, and make a determination whether he was competent at the time to make the decision not to raise his mental health? I mean, given what we know now, can we really just uphold this first-degree murder conviction. I mean, I get it. There's plenty of evidence that he killed his father over the truck, and he did it with the plastic bag, et cetera, but we're dealing with his intent at this point. And there's all kinds of very troubling mental health issues that haven't been presented to the jury or anyone else, except for us.
And the Commonwealth would argue that in that case, the best option would be for them to file that motion for new trial, have an evidentiary hearing, and flesh out those issues that you're.
We decide our 33E prior to that.
The Commonwealth would argue that there are other cases where a defendant's mental health history doesn't overcome the weight of the evidence, and we would argue that in this case, the evidence, as discussed, is strong. There's overwhelming evidence that it was.
Well, there's overwhelming evidence that a murder was committed and this defendant did it. What is the evidence that the Commonwealth's relying on that he did it with the mental state required, given his extensive medical health history that we now have here that the jury was not presented with?
So it appears that the defendant took the steps after he killed his father. He was aware enough where he immediately fled. He got in the truck, he started driving to New Jersey. There's some indication that he knew what he did was wrong, which I think speaks to that he had the proper intent to commit the crime and to be found guilty of this.
So the fleeing, anything else?
Besides just what was stated before, where he kind of.
Well, no, yeah, not the details of the crime itself, but I'm talking about anything else about his mental state. So you're relying exclusively on the fact that the defendant fled.
I would say that is the strongest factor that would speak to him appreciating.
There is something in the record, and I'll have to go through it. I apologize, I haven't had a chance to do that yet, but something about a note left for Staples. What
Yes.
was that?
So Al Staples, which was the defendant's brother-in-law, he found a note in his truck. I believe it was the day after, forgive me, I'm blanking on the timeline. It was after the victim's body was found, a note in the defendant's handwriting that said, "Dad's in a better mood now," with a smiley face. That could also speak to the defendant's being able to appreciate what happened, but that was the note that was left in the car.
Okay, thank you.
On the notice issue, you were right. Justice Cipher points out that, to me, that it's an or. So you have to give notice of the mental impairment or if they want an examination. So.
Okay, thank you for that clarification. There are no further questions. The Commonwealth will rest on its brief.